On this episode of the program, highlights from the call to bar ceremony of over 1,400 new wigs. The chairman of the Body of Benchers, Chief Wole Olanipekun, uses the opportunity to reiterate the roles and functions of the Body of Benchers and the Legal Practitioners Disciplinary Committee. Also showing on the program, the Chief Judge of Lagos meets with representatives of the bar in Lagos for the usual bar and bench forum. Discussions center on how to improve the e-filing system in the state. We also have the highlights from the webinar, The Future of Nigeria's Justice System, organized by the Lincoln Alexander School of Law at Toronto Metropolitan University, Canada, and the Massfield Legal Practitioners, plus a recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. Let's begin straight away with the call to bar ceremony, which held on Wednesday, July 26th. We have details in this report. Owing to security concerns, this hall at the Secretariat of the Body of Benchers is hosting the call to bar ceremony for the first time. Over 1,400 new wigs are gathered here to be called to the Nigerian bar, having passed their bar final examinations at the law school. The arrival of the Body of Benchers kickstarts the ceremony. The Director General of the Nigerian Law School speaks about the security concerns which necessitated the change of venue, and also presents the successful applicants to the Body of Benchers for their call ceremony.
Amidst our joy today, let me bring to our attention a significant area of concern worthy of mention at this auspicious occasion, which is the case of heightened security situation in our dear country, especially around the host cities of our headquarters and campuses. To the glory of God, and as reported in my last year's report to your august body, all the orchestrated fears and rumors of imminent attacks on the Nigerian law school community never and will never see the light of the day. However, adequate safeguards of all the campuses and headquarters in Buhari, here in the federal capital, have been deployed and reinforced. Mr. Chairman, distinguished members of the Body of Benchers, I will be presenting at this call to the ceremony a total of 1,490 candidates who are successful at the May 2022 bar final examination.
After his speech, the DG presents his students to the Body of Benchers for admittance to the bar.
By the powers conferred on the Body of Benchers by Section 3, Subsection 1 of the Legal Practitioners Act, and by the powers conferred on me as Chairman of the Body of Benchers by Regulation 16 of the Body of Benchers Regulations 1983, I hereby admit each and every one of the 1,490 applicants herein present severally to the bar as barristers and solicitors of the Supreme Court of Nigeria. You may now put on your wigs.
The chairman of the Body of Benchers then goes on to give his remarks. He restates the roles of the Body of Benchers, the Legal Practitioners Disciplinary Committee (LPDC), and also gives his charge to the new wigs.
By this singular act, you have become full-fledged members of the legal profession. You have been admitted to the Nigerian bar to practice law as barristers and solicitors of the Supreme Court of Nigeria. When you were in the law school and were dining with you as benchers, you are being addressed as lawyers in equity. Henceforth, you have become lawyers in practical terms, in the real sense of it. For every one of us in the legal profession, it is now incumbent on us to address you from now as learned friends, particularly when we meet in court. Section 3, Subsection 1 of the Legal Practitioners Act, which establishes the Body of Benchers, provides, and I quote, there shall be a body of legal practitioners of the highest distinction in the legal profession in Nigeria, to be known as the Body of Benchers, which shall be responsible for performing the functions and duties imposed upon it under this Act. The Act makes no pretense about the fact that the body is constituted of legal practitioners of the highest distinction in the legal profession in Nigeria. It is the prerogative of the Body of Benchers to admit you to the bar. While you were in the law school, distinguished members of the Body of Benchers had signed your application forms. recommending you to the body itself to be called to the bar. The screening committee of the body, under the chairmanship of the vice chairman, had painstakingly screened each and every one of you, looking into the details of all your forms and particulars before recommending you to the body to be admitted to the bar. I've gone through these narratives in order to remind you of the preeminent position of the body of benchers in the life and career of any legal practitioner in Nigeria. Legal Practitioners Disciplinary Committee. As stated above, the Legal Practitioners Disciplinary Committee is a committee of the body of benchers, saddled with the responsibility of disciplining any legal practitioner in Nigeria, where his or her conduct amounts to infamous conduct in professional respect, in violation of the rules of professional conduct for legal practitioners in Nigeria. Over the years, the LPDC has continued to operate as an independent arbiter, enjoying absolute independence in the course of carrying out its assignment. The body of benchers does not and will not interfere with any of the proceedings or outcome of such proceedings before the LPDC. It is important to point out that the LPDC is not an avenue for dealing with perceived enemies or ventilation of grievances against fellow lawyers on personal issues. The decision of the LPDC is known as direction, and any appeal against that direction goes directly to the Supreme Court and not to the body of benchers. May I plead with you, as you join the bar, to always strive at being an added value to the nobility, to the honor, to the dignity and respect of the profession, rather than coming to deplete and discount the established virtues the profession has stood for over the years. It is my prophecy that in the near future, we sprout Chief Justices of Nigeria, Justices of the Supreme Court and the Court of Appeal, judges of various high courts, chairmen and members of the body of benchers, attorneys general of the respective states, legal secretaries, advisors, directors, and counsel to multinationals, presidents and governors of respective states. Or you don't want to be president. You don't want to be governor. Members of the national and state assemblies, captains of industries and statesmen that God will use to foster the renaissance of our dear country, Nigeria. But I shall do further, that when you get there, do not envy, for envy is sin. Rather, appreciate those amongst you who are doing well, rather than trying to pull them down. In other words, do not get enrolled in either a PhD course or school. And by PhD, I mean pull him or her down. Honor and respect your seniors. And when you attain high offices, extend courtesies and respect to your seniors and predecessors in office. Do not run them down or speak ill of them. I pray that in due season, when God elevates each and every one of you, and you become the sinus of eyes, may no power, principality of blackmailer be able to bring you down.
Following these admonitions, the ceremony is concluded. But many commentators believe that some of the comments of the chairman of the body of benchers may not be unconnected with a call by the Nigerian Bar Association for him to step aside to allow for the LPDC investigate an alleged act of professional misconduct by one of his partners, Adekunbi Ogunde. Indeed, reactions have not stopped trailing the NBA's call. Senior Advocate of Nigeria, Jibrin Okutepa, has condemned the NBA's move, insisting that the letter was not done in the best tradition of how things are done, irrespective of what anybody feels. He goes on to say that Chief Olanipekun was a past president of the bar, and whether anyone likes it or not, he is a superior member of the bar. To do a letter to him and before he gets it, it is on social media. It is a very terrible thing, he concludes. But another senior advocate of Nigeria, Yemi Kandi Johnson, has asked Chief Olanipekun to resign. He says, in the face of public allegations of egregious professional misconduct, I would expect him to defend the profession first before himself, and accordingly to resign from the office that leads the profession. It's a matter of responsibility and of honor. The president of the bar, Olumide Akpata, has himself said that there is nothing personal between him and Chief Olanipekun. He also expressed disappointment that at the last meeting of the body of benchers held a day before the call to bar ceremony, nobody raised the issue of the letter, a clear indication for him that many people are hypocrites who only like to play double standards. To another topical issue, the Attorney General in Lagos State and some senior members of the bar in the state, including branch chairmen, have met with the Chief Judge of Lagos and other members of the judiciary to deliberate on the dysfunctionality of the electronic filing system of processes through the State's Judiciary Information System, JIS.
The meeting of these senior members of the bar with the bench was not open to the press, to allow for frank discussions and for all parties to speak freely on the issues clogging the wheel of justice in the state. After the meeting, the parties briefed on some of the discussions that came up. The chairman of the Judiciary Relations Committee starts by putting the issues in context.
The key problems with the judiciary information systems are the human interfaces. And this meeting has been very useful because we've been able to point out in detail to my Lord the CJ and his colleagues in the judiciary where those human interfaces take place, and also establish that it is possible to dispense with those human interfaces. I think it's a mental block transmuting from what was a manual system to a digital system. So we're trying to run a digital system, but with still quite a few of the hang-ups or hangovers from the manual system. Once that is done, I think this system has the potential to revolutionize the efficiency of the judicial sector in Lagos.
And we felt that Lagos, being the epicenter of litigation in Nigeria, it's a gateway to the judiciary. And so people brought up a lot of issues on how the administration of justice is almost grinding to a halt by virtue of the fact that the e-filing system in Lagos State seemed not to be working. And we pointed it out. I went there personally to have a first-hand experience, and I related my experience to the Chief Judge and also the Honorable Attorney General and the Judiciary generally. And we had a lot of discussions and agreement on the need to remove human interface in most of the areas where we've experienced delay so far.
Apart from the need to remove much of the human interface which slows down the process, the senior lawyers also spoke on the key takeaways from the discussions.
Ordinarily, in situations like this, you see CJs who want to do it alone without an input from the bar. But this is a man that has a larger heart and has a desire to ensure that administration of justice is delivered, efficiently. He has called all of us. You can see the input of those lawyers who are in practice, who even experience those delays in filing, bringing to bear their experience and then looking at those factors that hinder and then removing them in order to create efficiency in the system. So that's my takeaway, that very soon every law firm in Lagos must understand that we are migrating into e-filing, and you have to do it now by yourself in the comfort of your office.
We need to cut cash. There's a lot of fleecing by bailiffs, a lot of demands, it's arbitrary. A lot of times you want to serve a process, you've paid the official fee, and at random somebody just says, bring 10,000, or bring 15,000, or bring 20,000. I've had to do so many complaints because I have like a standing policy in the office with my clerks, and I'm always like, no, it's either official or if it's reasonable. So if you eliminate cash, we don't mind paying more, and then you eliminate cash, and we actually know that it will be served. And I don't see why there can't be buses, bikes to serve, these processes to eliminate those areas of cost.
It's about a mind change. It's also about technology, making things more accurate and making things a lot better. So I hope that from what we've decided today, we start transiting from the point where we do things manually, so nobody's recording the exact time manually, but now we have systems that have been configured to tell everyone what the time for the filing or the initialing of the process is. That's one. And that takeaway is the issue around scheduling of cases. So it's important also that we have a process that takes the matters automatically. Are they going to the family court? Are they going to the commercial court? Are they going with little or no human interference? So that somebody can be behind the system, just clicking and assigning the matter. So it is seamless.
The Chief Judge of Lagos State says the discussions were frank. He gives the assurance that the problem of lack of space for the e-filing registry will soon be resolved, as the judiciary is set to take over new court buildings, especially within the Lagos division.
Both sides have been forthright about what's on ground. And on the part of the judiciary, areas where we need to improve or put in place certain mechanisms, we have agreed to go back and look at them. And if you heard us, we've also agreed to do something like a joint task force and see what improvements we can make within some short time. But like I announced, there are some of our buildings that are coming up, and we should be able to have reasonable space that is fit and proper to accommodate particularly our GIS unit, and for us also to put in adequate infrastructure and personnel. So hopefully before, in another 3 months, so to speak, we should be able to move to that new location and then properly situate our GIS unit in Lagos there. So that's where we have the chunk of the problem, the Lagos GIS unit.
Welcome back. We move on now to the webinar organized by Lincoln Alexander School of Law at Toronto Metropolitan University, Canada, and Massfield LP. Here are the highlights from that event.
As many of you know, Nigeria's justice system has witnessed its fair share of some of the instability that has faced Nigeria as a country over the years. In this sense, the administration of justice is challenged by inefficiencies that impact access to justice for litigants on the one hand, and a crisis of governance involving operators of the justice system on the other. In responding to these issues, we've put together 2 back-to-back panel discussions.
With these words, the moderator of the webinar, Dr. Uche Ngwaba, an assistant professor at the law school, set the tone for the conversations on the sub-theme, efficiency and access to justice, discussed at this webinar of the Lincoln Alexander School of Law and Massfield LP, a dynamic future-focused law practice. The webinar brought these key stakeholders from the legal community together to explore the future of Nigeria's legal system. The first speaker, Senior Advocate of Nigeria, Anthony Digbe, in his contribution, examined the history of court governance in Nigeria, highlighting some of the weaknesses.
Further, there is inconsistent jurisprudence on judicial governance. For instance, in Nganjiwa against FRN, it was held that only the NJC can deal with corruption charges, and a judge in active service cannot be investigated or tried in a court of law unless such a judge is first removed from the bench. But contra the case of Onedian, where a former CJN was tried before the Code of Conduct Tribunal while he was in office. So some of the consequences of the weaknesses in the governance structure include nepotism, cultism, corruption, promotion mentality within the judiciary, exclusion of career commingling at the top echelon of the judiciary, inability and lack of willingness to attract the best to the judiciary consistently, poor management of the justice delivery system, delay in justice delivery, decline in quality of judgments and justice obtainable, increase in resort to self-help by the citizens, rise of non-state supported alternative justice systems such as OPC, Bakassi Boys, Herdsmen, etc., breakdown of rule of law, and prevalence of impunity. Now, are there remedial tools available for rescuing the judiciary and guaranteeing the future of the institution? I think there are, but it may involve constitutional amendment. It may also involve the implementation of the MBA recommendations and the draft bill for reform of the legal profession.
The other speakers proffer some solutions and reforms necessary for the future of Nigeria's justice system.
Let me bring in the views of somebody everybody knows about, Adam Smith, the father of the theory of political economy. He wrote that book in 1776, entitled The Wealth of Nations for short. In it, he examined the different factors that contribute to the economy of a nation, above all, he said, there's nothing that gives greater encouragement and most effectual encouragement to all sorts of industry, and remember here, all sorts of industry, than the administration of justice. It is for that reason that proper funding of the administration of justice is something that must be done for the benefit of society as a whole. And I would again move it to access of people to justice. The proper funding of the judiciary requires judges to be paid adequately and that pensions secured adequately. It is for the good of the people that this must be done.
In order to facilitate justice delivery in Nigeria, some of the other things we need to look at are one, infrastructure, and two, manpower. And those are the two areas where we still have a lot of gaps. I think the pandemic sort of showed that very clearly when the pandemic hit. Apart from the courts, every aspect of our justice delivery system is lagging behind when it comes to technology. If you look at the law enforcement agencies, a lot of things are still done physically and by hand, not enough records that you can access and process to be able to deliver justice at the speed and at the pace that is required for the 21st century.
But in a country like Nigeria, for example, where infrastructure, electricity, power supply is critical in terms of any technological onboarding you want. You also have the issue of economic, the fact that the resources that are allocated for this public service should be provided in a manner that does not exclude the generality of people who cannot afford alternative sources of power in order to access this technology when it is deployed. And I would also want to end my intervention around the classes of people engaging the justice system. So when you have women, children, or people who traditionally have been excluded from society in terms of opportunities, whatever methods we deploy have to definitely take into consideration gender responses, also responses in terms of the ages, the status of people engaging in it, to ensure that the system that is deployed does not discriminate and provides a level playing field as much as possible.
A second panel session dwelt on the operators of the justice system, touching on topics such as qualification and recruitment of judicial officers, continuing legal education, and training and remuneration of non-judicial staff. On the home stretch, let's give you a recap of some of the top legal stories in the news.
We begin with the report that the Federal Capital Territory High Court has granted the suspended Accountant General, Mr. Ahmed Idris, bail in the sum of 5 billion naira. Mr. Idris, who is being tried alongside 3 others for alleged fraud to the tune of 109 billion naira, is also expected to present 2 sureties, a director and a permanent secretary in the Federal Civil Service. The 2 other defendants, Godfrey Olusegun Akindele and Mohammed Kudu Usman, were granted bail in the sum of 2 billion naira each, with 2 directors each as sureties in like sum. In her ruling, Justice Adeyemi Ajayi ordered that the defendants are also forbidden from travelling out of Abuja throughout the trial, except with the clearance of the court. Still in Abuja, the immediate past Minister of State for Education, Chukwuemeka Nwajuba, and a group, Incorporated Trustees of Rights for All International, have filed an originating summons before a federal high court in Abuja seeking an order declaring Nwajuba as the authentic presidential candidate of the APC. They're also asking the court to cancel the votes of the presidential candidates of the All Progressives Congress, Bola Tinubu, and the People's Democratic Party, Atiku Abubakar. Nwajuba is also accusing the APC presidential candidate, Bola Tinubu, of bribing delegates with dollars. The former minister presented 26 issues for determination by the court. A senior advocate of Nigeria, Femi Falana, is accusing the People's Democratic Party of scheming to frustrate opposition political parties in Rivers State ahead of the 2023 general elections. He alleges that the PDP is seeking to eliminate other political parties in Rivers State from the ballot through the courts to pave way for an unchallenged contest in next year's elections. Mr. Falana made this known at the Federal High Court complex in Port Harcourt, Rivers State, where the PDP instituted 3 suits seeking to disqualify candidates of Accord Party, Labour Party and Social Democratic Party in next year's National Assembly elections. The PDP had dragged the Independent National Electoral Commission and some of the opposition candidates of the parties before Justice Dela Pam to challenge the conduct of the primaries of 3 political parties and asked the court to compel INEC not to recognize the candidates. And we round off with a report in Kano, where the State High Court has sentenced to death by hanging a school proprietor, Abdul Malik Tanko, for the murder of late Hanifa Abubakar, a 5-year-old pupil of Noble Nursery and Primary School who was alleged to have been kidnapped and subsequently murdered. The remains of Hanifa was detected and found in one of the school premises in Tudunwada area of Kano State, where she was buried by Abdul Malik and his accomplices. The Kano State government took the case to court, and after several sittings and the testimonies of different witnesses, the presiding judge, Usman Naba, found the school proprietor guilty and sentenced him accordingly.
And this is where we adjourn till next week. Don't forget that you can find this episode of the program and past episodes on our YouTube channel. After viewing, be sure to leave us a feedback. I'm Shola Sheyeli. Thank you for watching and see you next time.